Hello, everyone. My name is Diane Cohen, and I would like to thank you on behalf of our sponsors, WorkComp and Motion, for joining us today. Before we get started, there are a few housekeeping things I would like to take care of. The first is that the webinar presentation is attached to this to the control panel on the side there. So if you would like a copy of it, please download it before the end of the presentation. Second, if you need CEU credits, you will be receiving an email that says your certificate has arrived. It will come from customer care at gotowebinar.com. So please be sure to download that. There'll be a blue button. You just click onto that and it will download. I would like to thank our sponsors today for bringing this fantastic program to you. WorkComp Partners, MacroPro, SMS, ProCare, GenX, NuQuest, iRatings, Learning Services, Ember, Court Reporting, Optum Dental Works, and California Orthopedics. We'd like to thank all of our sponsors for bringing this program to you today. Today, our presentation is Innovative Solution Strategies through Dynamic Partnerships. We have an outstanding group of speakers, and they are Marc Ponce, who is the Southern California Workers' Compensation Manager for Albertsons and Bonds, Bridget Smith, the Vice President of Compliance and Customer Relations for NuQuest, and Scott Stettler, Managing Partner of Siegel, Moreno, and Stettler. I'd like to thank all of you for being with us. I would also like to tell the audience that Marc is not going to be seen on camera. However, you will hear his voice and he will be participating via the phone. Thank you all for being here.
Thank you.
Thank you, Diane.
Thank you, Diane. Thank you for the welcome. Okay, well, we're going to go ahead and jump right in. We are in the slide that says your settlement toolbox. And so here's a list of things that we found to be useful with settling claims. First thing you have to really do is evaluate your team's claims landscape. Understand what you have, what results you need, and apply a targeted approach. So first thing you need to do is ask yourself, where are all my risks? Do I have too many high dollar reserves? Do I have too many old claims? Do I have too many claims that are nearing Medicare territory? These are the things that you really need to ask, so then you can tailor your approach and how you want to tackle your settlement initiatives. What you can do is you can target, focus on all categories, or focus on one category that gives you the best return. Next, you also need to figure out and understand your supervisors and your examiner's strengths and their skill level. So by doing this, if you have a group of examiners that are very seasoned, you can apply that to a future medical desk or a resolution desk. But you have to find a balance, because what you don't want to do is to have a resolution desk for somebody who is still learning the business and the job of a claims examiner. And if you do a resolution desk, you may stunt their growth, because now you're just focusing on resolutions and you're not getting into the beginning stages of a claim. So you need to find that balance when you're doing something like that. Next is to have a very strong partnership with your MSA vendors, your structured settlement brokers, and also your defense counsel. It says here, it says professional administrator provider. That would be a TPA, and also make sure you have a solid relationship with your defense counsel. Last but not least, make it fun for your team, make it a friendly competition, and incentivize. Next slide, please. And speaking of making it fun and friendly competition, here's some ideas that we do use here at Albertsons, and I've used this with other teams that I've had before. First thing that we're looking at is, this example is looking at your highest reserved claims. You can look at it as a top 40, like make it fun, something that people can relate to, like, the top 40 with Casey Kasem show on Sunday mornings. Make it fun like that so people can relate to it, make it fun, and take pride in. So when you look at top 40, you can actually do this two ways. You can do a department goal of your top 40 highest reserved claims for the entire inventory of claims that you have, or the supervisor can also establish this with his or her team. And each examiner, they can also have their top 40 highest reserved claims. And by doing that, now you're splitting it two ways. You're cutting the pies so many ways that you're targeting it from a department goal, and also at the desk level. So this is really going to pay off because it's going to pay off so much more than just one approach. So if it's a department goal, you share the vision, you have a poster board in the entire department so they can see it. So you can showcase the progress. You can be creative here. You can use a thermometer. You can do a mountain climb, that kind of stuff, so people really can see it and visualize it and see the progress and what all the good that's happening for the team. But at the examiner level, the one thing here that I really love is when the supervisors do this, and this really will show you who is going to shine in this project or this settlement initiative that you do. The ones that do shine, those are the ones that are going to be next leaders in your organization. So it's not just settlements anymore. It's developing people, and you're also developing folks that are going to be in leadership down the road. So like I said, this pays off in so many different ways. What I like to show here is this is the visual that I share with my team. I showcase this. I have a board. Last year we had a theme of Jurassic Park, and you can see here the 3 units that I have. These are all the settlements that they did in 12 months. So 521 settlements in 1 year. That averages about 43 per month settlements. That's a pretty good number, and compared to other projects that we've had in the past where we don't collaborate with other ideas. But this has really paid off. And in 2020, we're already tracking at the same rate. And last year, for the team that had the most, which is here, this the team Triceratops or Triceratops, they had 203 settlements in 1 year. So for that, we give them a prize, we give them a trophy, and we gave them a Dynamite Award for 2019. Okay, next slide. Next slide is when you make it fun, when you make it competitive, a friendly competition, don't forget also to make sure that you share with the team the vision, the purpose and the big picture of it all. It's just, we're not just settling claims because we settle claims. There's more to it than that. So why are we doing this? You share the visual, you update the team regularly, then you discuss opportunities to improve in any areas that you may be not catching up as from where you were the year before. So in doing this, because where I am, I'm in retail. We're basically a grocery store company that happens to have a in-house claims department for workers' compensation. So my department, we don't contribute in sales and revenue. We basically spend money, within the organization. So for us to really contribute to the organization, we have to spend less. And by doing that is to come up with ways where we can save money for the company. And why do we do that? Just because it's not just savings. With savings, when we bring back salvage and money back into the company, we can reinvest those savings into technology, machinery, or just sprucing up our stores. Some of our stores look a little old, and we want to give it a nice facelift. So a lot of this stuff goes back into the company and gets reinvested in to move the company forward. Next slide, please. Okay, so what is the best settlement strategy, right? You ask anybody in the business, they're going to say CNR everything, right? Yes, of course, CNR is the best way to settle a case, right?
Can I jump in real quick? I'm sorry, Marc.
Sure, of course, sure.
So I think we need to just go back one slide.
Yeah.
Go for it.
Thank you.
Mm-hmm. So are we now at the slide that says provide the purpose and big picture?
We are now at the sign that says, what is the best settlement strategy?
Oh, gotcha. Okay, perfect. So the best settlement strategy is by way of CNR. But there's many ways to get to a CNR. And the best way to get there is make sure you position yourself for success by having solid quality investigation. If you don't have that foundation, you're not going to get the best result. So make sure you have all that. You take statements, anything that's red flag, you get a statement. If there's anything that is indicating this person is working elsewhere, get surveillance, get your indexes. get your subpoenaed records, all that. Make sure you have all that done at the beginning, and you continuously do that throughout the life of the claim. And also by doing that, evaluate the claim at every stage. Conduct a cost-benefit analysis. How much can we settle this claim now versus later in the future? And what if we don't, and a question I always hear is, what if we don't have an MMI report? Can we still settle, or can we not settle? Certain claims can settle, as long as you have a good faith estimate of permanent disability and future medical care. If the parties agree, you bring it to a judge, chances are you can get that approved, as long as your good faith good faith estimate of PD and future med are reasonable and fair. Make sure that you use all your resources too to maximize your cost savings.
Mark,
you use your MS.
On that note, just the way the WCAB is operating now is entirely remote, and so when we have cases where we're doing creative settlements, there's no MMI report, but there's obviously valid reasons for settling the case. We don't have the opportunity to go whine before a judge and try to lean on them to get a settlement approved, but they are permitting, and you can pass this on to your defense attorneys that you use. They will allow cover letters. So particularly in those cases, a detailed explanation of exactly what's going on and why you're coming to the resolution you are is permitted when you upload the documents to the WCAB. So some people think that they're sort of limited only to the settlement documents, medical, EDD, child support type of things. You can also submit a detailed analysis of why you're coming to the resolution, FYI, BTW.
Right. Mm-hmm. Absolutely. Yeah, thank you for that. And last but not least, our very favorite, settlement at the deposition. It's a very good tool for us. It's been successful in many cases. Like I said, at the deposition, make sure you have a solid investigation. All your materials are ready. Those are key. That will set you up for a better result at the depot with regards to settling the claim. Also, look at the years of service that employee has with the company. Is this a new hire, or this person has been here for quite some time? Is it a disgruntled employee? What are their motivations? So you make sure you touch on that before going into the deposition. That way you can strategize on what you want to do at the depot. First notice litigation claims, we do get quite a bit of those, and we have been successful in settling at the deposition. Most of these ones are, most of them are red flag claims. There's a lot of issues with the claims. Employers are blindsided by some of these things because they've never heard the person ever complain about an injury, but all of a sudden here's an application. So, and if you do something like this, make sure you have a standalone signed voluntary resignation. It cannot be with the CNR. It has to be a standalone document. And if we can go to the next slide, please. And this goes into resignations. So resignations has been something that's been addressed in late 2019. There was a change in how resignations are to be conducted. And there's a lot of literature here, but what this basically says is the AB 749 signed by the governor in October 2019, effective January 2020, basically it prohibits any settlement and prevents employees for return employment with the same company or any affiliates. So what our HR has done to address this is we've taken out the no rehire language in the resignation. And that's basically what's been done at the organization level in addressing this AB 749. But still, you can still get one. Just make sure it's standalone, and make sure you share that with your HR department. Because what we're seeing now is the person did resign, but there wasn't one signed. Now they're calling back the employer 2-3 years later and saying, hey, when can I get back on the schedule? And if we don't have this, it'll make it tougher for your HR department to address that. So make sure you have this standalone document in your file, and make sure you send a copy to your HR department. All right, next slide. How to settle cases in an eye of a hurricane. Okay, so this slide basically for me is be prepared at all times. Be prepared. Depositions, when you do that, make sure, like I said, solid investigations. When you go in there, you don't want to go in there empty-handed. You have to have all your ducks in a row, investigations, and make sure you give some settlement authority to your defense counsel. That way, we can settle, and if they don't want to settle, we go straight into the deposition and we go through it. But the objective is get in there and present your evidence and get it settled. And if not, then you proceed with the deposition and you litigate it that way. So that's key for me. And for documentation, make sure you have all your benefit printouts, you have all the body parts all corrected in the documents, have that written up in the CNR. When you go in there, have the CNR written up already. That way you go in there with the intent to settle. If not, then that's fine. I mean, we can deal with that too. And also, settlement authority requests. Sometimes we go in there, it may be a high dollar claim. Make sure that when you ask for settlement authority from your supervisor or your manager, make sure there's money in the reserve that you're asking for. Sometimes people ask for $100,000 and there's $25,000 in reserve. Make sure all your documentation are there and it reflects the actual exposure of the claim. Last but not least, know your venues, which WCAB you'll be going to, because there's certain judges there where you have some of your defense counsels are more familiar with the judges there. Use that to your advantage. And also with the WCAB and COVID-19, some of the trials are going to be virtual. It's coming in the near future, and from what I hear, they're being scheduled already. So that's something that we need to look out for in how we prepare for trials going forward. And with that, I will hand it off to Mr. Scott for the next slide.
Thank you. You know what? You can leave it on that slide for just a second if you would. Go back one. Yeah, perfect. The WCAB does have the equipment right now. No, go forward one. So will the WCAB move to virtual trials in the near future? Can we tell if any of our attendees are WCJs? Okay, I'm going to take that as probably not, but we've been running into a significant reluctance to try cases, and there's many reasons for that. Certainly judges and many of the parties to a case don't want to try a case unless you can actually see the applicant and determine whether they're credible, their demeanor during trial. So almost every single trial that has credibility issues has been deferred and keeps being deferred. And that's because the judges want to see the actual applicant when they testify. Now, the WCAB has received the video equipment necessary to move forward with virtual trials. And the latest I heard, which was about a week ago, was they should be up and running in September or October. So a lot of trials have been kicked out, but we may actually be able to get the show on the road and get those trials heard. Next slide. If you look at this slide, it paints a pretty clear picture of the difference between an unrepresented claim and a represented claim. The cost differences are significant. So as we slide into now the litigated claims, which is 99.9% of the claims that I have, except for the troubled applicant occasionally, you'll see that we have a significant dollar differences. So one of the important things working with your defense counsel is the budget that they're working with in trying to accomplish what's best on the case, and then also trying to get a case resolved as early on as possible. We certainly all hate the look back claim when we had a claim where it was close to settlement at $36,000 and now you're at the $275,000 mark and there's MSAs and the world's coming in on the case. So as Marc pointed out, evaluate settlement at every stage, including unrepresented, represented, whenever you can get a settlement. As the old adage goes, a good claim is a settled claim. Next slide. So before I get started on this, just to give you a little bit of background on myself, I passed the bar, I think, in 1999 or 2000. I started practicing. I've been in workers' compensation ever since. And prior to workers' compensation, or prior to passing the bar, I was employed at Golden Eagle Insurance and Liberty Mutual Insurance. And so there's going to be a question about temporary disability coming up, and I wanted to do a little quiz question here, or trivia. What was the maximum temporary disability rate when Scott Stettler started in workers' compensation? Now, realize I started when I was about 12 years old, so I'm really not that old, even despite whatever the video camera reflects. But if you email me your answer, because the answer is going to be revealed in a slide or two when I go over maximum TD rate when Scott Stettler started in workers' compensation. Okay, so depose or not depose. One thing that I didn't like when I was an examiner is that every time I referred out a case, on the to-do list was always a deposition. And that could be if I'm referring the case out because I'm having a difficult time settling it. I certainly don't want to do a deposition. So when I get a case, I carefully evaluate it whether we need a deposition or not. And as Marc touched on in his presentation, it does offer an opportunity for early settlement. There are particularly in Southern California, where you have these large firms that just turn them and burn them, a lot of things can happen at that initial deposition that'll allow resolution. And when I have on here initial contact, I'm actually putting the initial contact is between the applicant and the applicant attorney, because they probably never met before. So they get a feel for them and they can kind of determine whether they want to resolve. I try to reach out to the employer before I do a deposition to find out the length of their employment, whether it's somebody that they don't want to bring back, and how much emphasis we really want to place on trying to get this case resolved. So this is a case that has been referred over. We have a problem employee. I will schedule a deposition to try to get that case resolved. And having been in the business for a long time, you know the applicant attorneys that you can do that with, and then you also know the applicant attorneys you can't do it with. And then I really evaluate, do we really need a deposition? So one of the most important things that we do in considering a deposition is getting that past medical history. And important on that is getting their regular treating physician's identity, prior workers' compensation claims, prior personal injury claims, things of that nature. And a lot of that can be done first. When I look at the file, I'm looking through those medical reports to see if that's already identified. And a lot of the adjusters that I work with do a really good job in their initial setup, making sure not only have they identified the treating physician, but they have the applicant sign a release. That takes a lot of the reason for a deposition out of the need is now gone. So it allows you to really kind of bypass that 60-day period where you're doing a deposition and kind of move on towards either getting a med legal or trying to shut it down. Now, there are times when I feel a deposition is critical. And first and foremost is that if you have a fraud case, a deposition is necessary to get them to raise their right hand, swear under penalty of perjury that they're going to tell the truth, or in their case, not tell the truth, and get that on a deposition transcript. That allows that to be pursued by the district attorney. And so depositions are absolutely crucial on fraud cases. Also in injury AOE, COE cases, it's important because you've got to get their testimony down. Their testimony differs from the medical reports, differs from what they told the employer, differs from what they told the claims examiner. Those are all things that we can shred them on in cross-examination at the time of AOE, COE. And I can tell you the number one issue that allows you to win at trial at the WCAB, which we all know is a very defense-oriented place and hands out a lot of take-nothings willy-nilly. But the one thing that'll help you significantly with that is being able to do an effective cross-examination and show the applicant is incredible. That really, most judges that upsets, and that's a path to victory on those cases. Next slide. Pardon me. That didn't come out. Next slide. There we go. Okay. To depose or not to depose, cons. you have the cost of it, going through all of those. When you get through wages, paying an applicant attorney $400 an hour is absurd in my mind, but that's the going rate. When you get through with all the costs, you're looking at somewhere between $1,000 to $2,000. So if we're looking at a case that's a low back strain and we're talking about a DRE category 2, how much can I really gain at a deposition that's really going to save that much money on this case? So we also have to consider what the cost of it is, which versus what the value of the case is. And then additional things that I try to consider when I'm considering a deposition is if I see a number of body parts that have been pled and they're not in the medical reports and they're not being addressed just because when they sat down with the applicant attorney, they came up with a laundry list of body parts when in fact the only thing that really hurts is their shoulder, but it's not being pursued. I don't necessarily want to give them a forum in which to testify about how bad their knee hurts from their shoulder injury. So that's one where I kind of veer away. Same thing with some of my large employers that have had long-time employees. There may be a number of claims that have really just kind of died on the vine. It gives them an opportunity. If you go into a deposition and you start asking about prior injuries, next thing you know, a week later, you have 4 new applications on your desk. Clearly not something that we want to result from a deposition. And chance for attorney to meet applicant. Oh, that goes back to my first one. Sometimes it's bad when they meet because they only pled back and they never meet their applicant attorney, and then they realize they have back, leg, psych, and all kinds of things. So obviously things that we want to consider before we set their deposition. And again, you're looking at a 60 to 90-day add-on when you do that deposition. So trying to get cases resolved early, which is what our seminar is about. The importance of it for me is make sure you actually need a deposition before you go through the cost and the time and the expense. Next slide. Med legal evaluations. Hold on one second. So this is the cost I listed down there are for orthopedic and psychiatric, and in my experience over the years, what the cost differences and the highs and the lows. I've also received a chiropractic report that was over $20,000. I don't think we still paid it yet, but anyhow, obviously, you're talking about a hefty price tag that comes with panel qualified medical evaluations. And similar to depositions, we have to evaluate whether, in fact, we need a med legal evaluation. And things that I consider and I discuss with my clients, for instance, permanent disability value. Again, if we're talking about a DRE category 2 low back strain that's at 6%, there's really not much more we're going to do to shave that. Typically, that we found now that since we've been in the AMA guides business, if a person has back pain, typically a panel QME is going to give them a DRE category 2. So your difference in percentages are relatively low. And do you need a panel QME to come in probably similar, just below or just higher, and spend an additional, with a panel QME, you're looking at 90 to 120 days before that case is done. Even if we value slightly the higher the treating physician's report, I say get that case resolved. Similar with apportionment, if we start getting into cases where we're in DRE category 4 or DRE category 5, 10% apportionment is easy to justify a medical legal evaluation. It's just when we're in our lower shoulder injury, elbow injury, knee injuries that typically there's just not that much variance. And now, if you haven't emailed me about the maximum temporary disability rate when Scott Stettler started in workers' compensation, this is your last chance. I'll give you 3 seconds more. Actually, I'll give you a couple more. So one of the most important things for me in trying to keep costs down on a case is termination of temporary disability. The maximum temporary disability rate is now $1,200 or right around there. And so you talk about 2 months of temporary disability and you're getting close to $10,000. You can have a $100,000 temporary disability case, and the temporary disability is the tail that's wagging the dog in this whole thing. So getting a panel QME when you think that we are at a reasonable place where we could have a finding of permanent and stationary status is critical. Even if you disagree with the treater and we have to try to resolve that somewhere in the middle, or we think we're right on it and we go to trial on it, at least we have a chance. If we don't get in there and give at least some reason that we can terminate temporary disability and move the settlement process along, it won't happen. And sometimes our MPNs aren't as solid as others, and we have treating physicians that we know are going to extend temporary disability for a long time. So we have temporary disability rate now that is, like I said, close to $1,200, and the maximum temporary disability rate when I started was $336. Again, I was only 12 years old when I started, but hold on one second here. Next slide, please. My boss, Jennifer McCaw, put this in, I think, to torture me. I don't do a lot of safety officer work, so she wanted to make sure she included a safety officer case just to make me go back and look at safety officer law. But I think the reason that she put this in was because we're facing COVID cases, right? And the COVID cases, as you know, now carry a presumption. And when I say now, I mean through July 5th, from March 19th to July 5th, there's a presumption that if you work for your employer in the last 14 days prior to that diagnosis and or positive testing, and you're outside of the home, you're presumed to have contracted COVID at work. So it's a compensable claim, but it is a rebuttable presumption. And similar to these cases and how we are now trying to defend COVID cases, run similar with the safety officer cases, which have a lot of presumptions. One is, in this particular case, the Blaze decision, which was a cancer case for I think it was fire or safety. But in the presumed compensable cases, what happens? It's similar with cancer. It's similar with COVID. They have to fulfill a couple of things. In cancer cases, they have to be a member of law enforcement, fire or safety. They establish that. They have to establish that they have a primary site cancer, and they have to establish that they were exposed to known carcinogens. If you're a fire or police officer, you go into places that have just, smoky environments, bad environments, and it's basically presumed that you've been exposed to cancer-causing agents. So then once you have that, it shifts to the defendants to show that the primary site cancer was not caused by exposure to contaminants. And in this particular case, the individual actually had developed throat and lung cancer, but the panel QME, who did a very thorough job, was able to determine the primary site of the cancer was actually a breast cancer, and it was a male breast cancer that then metastasized to these other type of cancers. And they were able to show that the longevity rate or the dormancy rate of this cancer was beyond when he started as a police officer, so they actually overcame it. Similar in a COVID case. One of the things, a couple of the most effective ways in dealing with the COVID cases is if that particular employer, either in their section or generally, they don't have any other COVID cases, that's an indication that there's a strong likelihood that they might have contracted it elsewhere. And if we're able to get information that somebody in their household had it prior to them having it, that's a very strong indication. And I generally recommend denial in those type of cases. Now, I haven't gone to trial on any of these. Obviously, we're still in our infancy on this, and I anticipate that they're going to argue you know, they were asymptomatic carriers, those type of things. So we'll see how these cases kind of trend as we go along. Next case. Oh, wait a minute. Before we go there, I wanted to touch on one other thing, just to make sure you guys are fully done with me. If we go back, I think it's 4 slides to how to settle cases in the eye of a hurricane. Can we go back, I think 4 slides. One more. Okay, so I just touch on this briefly for what it's worth and how, I don't know, litigation is going to be done in the future, but similar to a lot of things, this pandemic is going to bring a new way of doing things at the WCAB, as well as, you know, doing things throughout our lives. I mean, you know, I envision that commercial real estate will be a difficult gig for the next few years because people are going to realize that they can work from home. And similar to that is the fact that WCAB moving to virtual trials. And right now, the status conference, lien conferences have not been real effective, but status conference, MSCs, things of that nature have actually run pretty smoothly. And it forces you to communicate with the other side a lot earlier than just waiting until you get to the WCAB. I find that it's an easier way. It's very cost effective as opposed to spending 3 hours at the WCAB. You're typically an hour or less on the phone in these conferences, unless of course you have somebody with your injured worker's last name starts with W, which happened yesterday, and he was at the end of a 26 on that, beside the point. Anyhow, it is an efficient way. It is a cost-effective way of doing at least the status conferences and MSCs. I predict that this is not going to change once this pandemic's over, however this pandemic ends. And so it really will be, I mean, it's a more effective way of dealing with a lot of things at the WCAB. The downside, of course, is not being able to be in person with a judge to lean on them regarding settlements and that type of thing. But you also have experienced counsel that have long relationships with workers' compensation judges. So overall, I don't expect that we'll see MSC and status conferences return. I think trials may return, but there'll be a different way of doing business going forward. And like I said, I think it'll be cost effective. It's good for the environment when you don't have 200 people driving to a WCAB and instead you're attending telephonically. So it's interesting. I think it'll be easier for attorneys to handle cases statewide as opposed to just their local jurisdictions, and a lot of other changes that are coming. So we're in for interesting times. And with that being said, we can jump ahead to where I left off. And I am going to turn it over to Bridget.
Thank you, Scott. And now I get to discuss the exciting topic of Medicare compliance. But actually, what we're going to talk about here today is not only Medicare when it comes to settling cases, but also mitigation in the process that goes hand in hand. And so we wanted to start out with really the 3 prongs of Medicare. And I like to refer to them as the ghost of Christmas past, present, and future. So the ghost of Christmas past are conditional liens. What has CMS paid in the past for this injury? And are you now considered a primary payer that they can obtain money from to recoup from those payments? So those are conditional liens. Section 111 is the ghost of Christmas present. Because right now, if you have a Medicare beneficiary, you may have to report if there is ongoing responsibility for medical, and in addition, if you've settled the claim. And so that information is used to really recoup information for conditional liens, for CMS's recovery effort. And then, of course, the ghosts of Christmas future, which are the Medicare set-asides. What's going to happen to the future to this claimant from what we can review now in the medical records that will require future treatment, and how much should be put aside for that. So they're really all, even though we talk about them separately, they're all really part of the same process. And the good news is that if an individual is not Medicare beneficiary, 1 and 2 can be crossed out. You may still have to deal with future allocations, but 1 and 2 would be gone. Okay, we can go to the next slide. So one of the things that we look at when we look at Medicare is really kind of a checklist of what needs to be done, because those parts, those different moving parts, need to be addressed at different times during your claims handling and during the life of a claim. And really the first issue is, as I said before, is the claimant Medicare eligible? And Marc addressed this a little bit in his first slide when he talked about the complexion of the case and when to settle. And really identifying when someone is Medicare eligible or close to Medicare eligibility is important for a lot of reasons. If an individual is Medicare eligible, then you've got that Section 111 obligation, you've potentially got conditional liens, and you've got the future allocation. If someone is close to eligibility, again, you don't have the liens because Medicare is not going to pay for anything if the claimant's not a Medicare beneficiary, and you don't have the Section 111, but you still may have an individual who's close to Medicare eligibility that you have to consider future interest. But if you have somebody who's not on Medicare at all, then the obligations may be a little bit different. There may be a point where this is a very complex case where the claimant will be on Medicare, and during that time there will be treatment that's received, and are you protecting Medicare's interest? But if you have a claim that is a really more of a claim that's a soft tissue injury or really doesn't involve all those complexities, and the individual's not Medicare eligible, then it's much easier to settle. And if someone's close to eligibility and you know when they're going to become eligible, that too can be much easier to settle. So that's the first inquiry on the claim that many of you do through your Section 111 reporting through the query process. The query process won't let you know if someone's applied for Social Security disability or if they've been denied benefits. So I always recommend getting that Social Security disability information. And right now, the Social Security Administration, with everything going on with COVID, is not really processing those too well right now. But obtaining those from applicant's counsel or the applicant, if they're pro se, helps you see exactly when the applicant will become Medicare eligible if they've applied for Social Security disability. And also, it's a good thing for your case in general to see what they were accepted for as part of that Social Security disability application, because it might be other things that impact your claim as well, and maybe impact in the age of COVID that we are in, their COVID issues as well. So the next thing is, really determining, do you need a future allocation of some point? And do you need it just for the settlement or to submit to CMS if you do a submission, or are you going to do a non-submit product? So how are you going to preserve those funds? Which way are you going to do it? Are you going to do it through an allocation that is something lower because it is not going to be submitted to CMS, it's below threshold? So there's a lot of different ways to look at that. And really it's part of the strategy of the settlement, part of the strategy of the claim. The other important thing I really want to mention here too is that if the claimant is Medicare, or the applicant, I'm from the East Coast, so it's the claimant, but if the applicant is Medicare eligible, then the applicant could be on both a Medicare Advantage plan and at some point could have been on a Medicare plan. So you could have a situation where you've dotted your I's and crossed your T's when you've gotten a Medicare Advantage plan or a Medicare, traditional Medicare letter saying that there's nothing owed on the claim. But if an individual has a Medicare Advantage plan, which is a Part C plan, they still assert the same recovery rights as Medicare, and they are extremely aggressive. So if someone is treated a lot, there's red flags for this too. If someone is treated a lot, then you want to, if you get it back at zero traditional Medicare lien, then you're thinking, great, this is great. But in your mind, you're thinking, who paid for that? That's when you think about that Medicare Advantage plan. And right now, approximately 33% of beneficiaries are on a Medicare Advantage plan, just because it provides all the benefits of Medicare, but it also allows the beneficiary to get more benefits. So it's very appealing. The best way to really handle it is just get a copy of the front and back of the Medicare card, and that will usually tell you. And also through counsel like Scott, or through at the claims desk to inquire as to, during the life of the claim, have you changed Medicare plans, or what plan are you on at this point? Because knowing that can really impact how those liens are handled. And then along those lines too, if an individual is Medicare eligible, then what are we going to report to CMS? Is it going to be, I cringe when I see codes of multiple body parts, right? You want to be as specific as possible, because all of that leads to what CMS kind of does in a batch grouping of the conditional lien. So if you're reporting all of these injuries and they're very broad, then the lien can be inflated arbitrarily because of that. So you want to make sure that what is being reported is descriptive, but also it's not overly broad, because it will impact your recovery. And if you have claims where you've reported something that is overly broad, like just back instead of low back or certain areas of the back, you can go in and change that reporting, but you need to know that as well. Same for termination of ORM. It should be terminated based upon not the administrative closure of the claim, but based upon either a note from the doctor saying unequivocally that the claimant needs no more treatment, or the passage of statute of limitations, court order, something definitive. And for TPOC, you want to be reporting when the settlement occurs. So these are all of the things that come into play. But if you think of the wheel and kind of divide them out in sections, I think they become a little bit more manageable. Okay, the next slide. Okay, we can go to the next slide. Okay, so now I think this is kind of the meat of the MSA, or the settlement, or the allocation, or just your claims handling in general when it comes to settlement. Mitigation tools. And mitigation tools are extremely important, and they can be that mitigation can be started as soon as the claim comes in the door, with how you accept the claim and what you are paying on the claim. So I'm not sure if there was a slide before that, but if one of the things that you're looking at are prescription. Was there a slide before that, I believe, that talked about mitigation? Yes, claim mitigation tools. Okay, so prescription drugs are a big driver in the claims, and in the MSA. So some of the things to look at when it comes to prescription drugs, obviously the one of the things that really pops out to everybody is, if there's a generic equivalent to the drug, will the claimant utilize that generic equivalent? equivalent? Do you have a nurse case manager on the claim that can help facilitate that? Is that something that claimants counsel, if you're talking about settlement, applicants counsel will work with you on? If we can show that the prescription was switched to generic and the applicant tolerates it, then that's going to be savings on the claim and savings on future medical. Also, one of the things that I don't think necessarily comes to mind, but it's a good option, if someone's on, let's say, 800 milligrams of gabapentin, if you switch the dosages to 4 200 milligram pills, that can save a tremendous amount of money, even though the applicant would have to take more pills. The higher the dosage, sometimes the more the pill cost because of the formulary of it. So checking to see if there are low dosage options that the claimant can take with just several more pills that they would have to take. One of the big things too, cleaning up ambiguous physician reports. Sometimes physicians go back and forth with their reports as kind of a cut and paste. So reaching out to the physicians to see if, with physician questionnaires or what have you, to see if really those drugs have been discontinued. And papering and weaning also is a good strategy. If the claimant or applicant is in a tapering and weaning program, the only thing I would recommend is that you really, it's a cost benefit approach, but you really don't settle the case until they're done weaning, because CMS, if you're going to submit it to CMS, they're going to look at what the applicant is taking now, not what is recommended for the future that they not be on drugs. So it's a timing issue as well. Okay, we can go to the next slide, which was the example. And that example is really with prescription drugs. Narcan is one of the prescription drugs that we've seen in recent years that CMS add when a physician is prescribing or when it's being paid for. And at first they added it a tremendous amount in the MSA, and we were able to kind of reduce that down based upon the shelf life of Narcan. But what Narcan is used for is for overdose. So sometimes individuals taking a lot of opioids will be prescribed Narcan. Now, Narcan, CMS has been allocating once per year, unless the records indicate otherwise. And the cost of that drug is $75 per year. There's another drug now that's in the market called Evzio. And Evzio, the cost for that per year is $6,100 for the brand and $267 for the generic. Does the exact same thing. It's the equivalent of Narcan. It's just that is a injectable, whereas Narcan is a nasal spray. That's the difference. Working with the parties to get on this other drug, with the physician to get on this other drug, that's a big savings in your MSA. So that's just one example. We can go to the next slide. Okay, and then we need to just go back one. So for claim mitigation tools, when it comes to medical treatment, just a few things. Avoid allocations during postoperative care. During that time, the applicant is going to be taking probably medications that they're only on postoperatively. They're going to be seeing the doctor much more. So allocations will be arbitrarily inflated, and it won't really reflect the claimant's life expectancy. It just reflects that moment in time. So you might want to wait at that point after that postoperative care has taken place. If there's a temporary exacerbation in the claimant's condition, and you see that there's going to be an end to this, again, that same strategy of, do I want to wait because the physician visits will lessen to, instead of 4 in the last 2 months, to maybe once per year. It can save a lot. Spinal cord stimulator trials. One of the things with spinal cord stimulator trials, a lot of times they're unsuccessful. So, is this a situation where you may want to have them have the trial, or if it's a situation where the claimant doesn't want it and the provider is really not recommending it anymore, that you could get it out via physician questionnaire or the expiration of the medicals. And we can go to the next slide. So following tools to consider: physician questionnaires. They should be narrowly tailored, not broad, and only applied in cases where the parties are on the same page with it. And this is where Scott comes in with the court orders. If there are court orders limiting any type of liability or treatment, that always impacts the MSA. Just of note, CMS will not accept a stipulation of the parties. It has to be a hearing on the merits. And we can go to the next slide. And then with post-administration tools for settlement, we're either talking about professional administration or self-administration. And, you know, lots of times, and we discussed this when we were going over this presentation, a lot of times, as Marc and Scott pointed out, the claimants just want to get their money and they want to go. But there's a huge benefit to those services of professional administration, and then offering more than just self-administration, but self-administration with support. The Medicare world is can be an extremely complex world. And if you do not use that account for Medicare purposes, it really will come back to haunt the applicant. And sometimes applicants have all intention to do that, and they just don't understand it. Also, there are capacity issues that can be a problem. And sometimes in cases, applicants want that additional help. So we've been seeing a lot more where applicants really want that professional administration, but self-administration support services is also a really good tool. That is where, you know, the vendor that you're working with basically will be there to answer the applicant's questions post-settlement on what's Medicare covered, what's not Medicare covered, can provide discounts for DME and physician services and pharmacy. The funds still remain with the claimant. The funds aren't directed to certain doctors, and they assist with bill review. So it's a helping hand if a claimant has been in the process a long time and wants that helping hand. And then again, with professional administration, you know, the professional administrator is doing everything on reporting to CMS to getting those tools as far as the discount pricing, and also can also be impactful if there's a situation where the claimant is misusing opioid drugs. If they have a pharmacy wall against that, that can help with that as well. So those are tools to settlement as well as tools to help the applicant manage the account. And I think that's all I had.
Hey, one quick comment before we go to raffle time. A couple of the inappropriate responses to my question. Did they even have cash back then? That's not funny. And Sandra 226. Come on, how old do I look? It was 336, 2 years later. All right. But I will get back to those, and some of you made the naughty list. Okay.
That's funny.
I thought they were asking 326 BC.
That's not funny either.
Before we go on to raffles, did any of our speakers have any parting words they would like to share with our viewers? I'm going to take that as a no, and now I'm going to reveal to everybody the prizes. So I have a slide. The next slide that comes up will show all of our sponsors. And again, we do want to thank all of our sponsors for bringing this program to you, and for all of our speakers. Thank you very much for speaking today and providing a wealth of information to all of our viewers. There we go. If you see your name on here, please know that you are a winner, and the company that is providing our sponsor will be reaching out to you to provide you with the door prize. So I'm going to leave this up for just a second, just as a reminder that your handouts are attached to this webinar if you'd like to download them now. Tomorrow, for those of you who need them, you will be receiving an email that says that your certificate has arrived. Make sure that you click the blue button and download your certificate. And we thank all our sponsors. Have a great day, everybody.